judiciary. That's probably particularly so because since the attention paid to judicial election is so small, money spent is probably likely to have a disproportionate power in causing the result. Okay, so much for selecting judges. More interesting topic, I think, is this question of judicial activism. This is complicated. Some of the characteristics that are thought to fall within the definition of activism are: 1, deciding cases on broad or constitutional grounds when more limited rulings will resolve the dispute. Secondly, ignoring, misreading, or overruling precedent or prior decisions of the court. Thirdly, invalidating executive or legislative action as contrary to the Constitution. 4, enhancing individual rights despite contrary majority views by broadly interpreting intentionally vague constitutional provisions. When some of those actions are taken, those who are opposed to the decisions often accuse the court of legislating or making law instead of interpreting law. Or the accusation is that the judges are permitting their personal preferences to interfere with judgment as to what the law might dictate. I want you to consider some real-life examples of what some people have called activism. It may affect your view as to the value of at least some forms of activism. First of all, let's take overruling precedent, not following a decision previously made by the court. If the United States Supreme Court didn't do that on occasion, we might still have racial segregation. Our telephones could be tapped without a judicial warrant based on probable cause. We would be unable to enact minimum wage laws. Also, corporations would be unable to spend at will to support or oppose candidates running for public office. That's the Citizens United case. Take the aspect of expansive application of vague constitutional principles, or, and this is subject to argument, adopting principles that are implicit, not express, but implicit in the Constitution. Those approaches have ensured an individual's right to birth control and abortion, same-sex physical relations, all those based on the concept of privacy, which is not expressed in the Constitution, but has been found by the court to be implicit. Some are more things that people have stronger feelings about than others, but my guess is that if you took the issue of a couple's right to use or purchase birth control, there isn't a single member on the United States Supreme Court now that would oppose that. Knowledge that a criminal defendant is entitled to a lawyer's assistance when arrested, that's Miranda, not expressed in the Constitution, but implicit. And indeed, that a defendant is entitled to have a lawyer throughout criminal proceedings paid for at least initially by the state or by the federal government. In the early days of the Republic, reliance on implicit principles gave us one of our most famous cases, Marbury versus Madison, and that established the Supreme Court's authority to overrule as unconstitutional an act of Congress or an act of the legislature. You will not find in the Constitution of the United States a statement that the Supreme Court has that power. And yet I guarantee you that there is not a member of the Supreme Court now, and hasn't probably been for hundreds of years, who would say that the Supreme Court erred in making that decision. Another aspect of activism relating to that is that it wasn't necessary in that case to even reach that issue. That was a principle of law that came about by what we call dictum, namely a statement not necessary for the decision, and yet in the decision. So that was a form of activism. There's some aspects of what we call activism that all of us tend to reject, including judges. Thus, we all accept that it is wrong to impose personal preferences or to ignore or misread prior decisions. As judges, we never knowingly do that, though we are suspicious sometimes of some of our colleagues who we think have done it, although they would assure us that they had not. Judges vary on the degree to which they tend to defer to executive or legislative decisions. Remember, that's one of the aspects of activism, failure to defer to the elected bodies. But there is not a judge in this country who doesn't also recognize that if the Constitution so requires, then the Executive Act or the Legislative Act must be overruled by the court. The battle, of course, is over the when, and that is very often a very complex decision. And it's particularly difficult because the applicable constitutional provisions are often vague and were intentionally made so by the Founding Fathers. Ideas like due process, those words are in the Constitution, equal protection, freedom of speech, none of those has a simple meaning. If you had asked the Founding Fathers at the time what they meant by it, you would have heard all kinds of different views, and they would have probably said to you, you know, some things are better left to be figured out over time. You're aware, I'm sure, that some lawyers and judges argue that the answer to difficult constitutional questions can be determined by finding the original intent of the drafters of the Constitution. The truth is, it often involves guesswork, it's often difficult, and if you read honest opinions by both sides of justices wrestling with that question, you can't help but come to the conclusion that chasing that rabbit is not going to be successful, that somehow you've got to approach the problem differently. We all recognize as judges, and you expect, that we will generally follow precedent. On the other hand, we also all agree that sometimes you have to overrule cases because they are, the earlier decision is simply wrong. Again, the problem is figuring out when and in what circumstances it's appropriate to do it. Sometimes you hear people talking about legislating from the bench or making law and describing that as something inappropriate when what we ought to be doing is interpreting the law. Well, the judges all agree, and I think people understand, that we're not supposed to make the law in the way that a legislature does. Legislature acts politically. Its acts are restrained only by the Constitution itself. The legislators can freely vote their own preference or those of their constituents, and then defend themselves when they're up